And the reason why I'm making that basis is we were getting some confusion on who was doing exhibits, et cetera, et cetera. And so I asked Faith to basically ask the defense team what was going on with the court reporter, and it says, this is from Sarah Clark, for the avoidance of doubt, Summer Green is a member of the defense team who will provide the defense with real-time and transcripts so as to avoid burdening the court staff with requests for records. So it does not sound that she is going to be the official record.
Understood, Your Honor.
So thank you so much, but you're going to have to move.
I've been requested by the state also to provide real time and
There, that's what she said. So she's asking for real time. That's up to the defense whether they're going to give you real time.
So we, I think both sides are using Ms. Green when we realized that she'd been hired by the defense. We wanted the real time also, just to even the instruments here. If Ms. Green needs a place to sit, she's welcome to sit over here. And I agree with the court. The official record is
That means that all the exhibits go through Faith.
Absolutely.
All right. So at the end of the day, she collects the exhibits. I'm sorry, David. All right. So if you don't mind moving, this is optics, and that's how it's going to be. I'm sorry. And then so
unplug into the audio stuff here so I can hear if we do the sidebars and everything.
all right, I'll let you do it today, but
And
tomorrow,
then I can just
yes, okay.
Thank you.
All right, so let me hear from you all on what I'm prepared to do is hear the motion on excluding late filed witnesses and then going into the motions in limine, and we can do state defense, state defense. What do you all want to do?
That's fine with the defense. I think many of the motions hopefully will be far shorter, and some of these issues, I think, have somewhat been dealt with briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. Some of those were raised in the middle, and some were not. So that's a fine system, and we're going to hope, at least on the defense side, to move quickly.
Okay. All right, so let's take up okay, State of New Mexico's amended expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. You can use the lectern or you can, yes.
You might want to turn that microphone on.
And just so you know, so everybody knows, if you have a green light, that means your microphone's on, and if you don't want anybody to hear what you're saying, you want to turn that off.
May I proceed here?
Yes.
Your Honor, the state filed this motion on June 26, 2024, after the defense disclosed on June 24th a witness by the name of Brian Winterstern, and I understand he is one of the producers of this film. Mr. Winterstern had not been disclosed by the defense on any of their witness lists prior to June 24th. And while they argue that the state had Mr. Winterstern on its witness list in the Hannah Gutierrez trial, we would respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state, at the last minute, added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense, and in fact, during the grand jury presentation, and it begins at page 186 of the grand jury transcript, Ms. Morrissey questions the state's expert Brian Carpenter about Mr. Baldwin's role as a producer. And so this is not something that was new to the defense. Under State versus Lemire and State versus Sanders, the state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has made. We didn't have an opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the state has no idea what he is going to be testifying about or any previous statements that he made relating to this particular case. Setting Gutierrez's trial aside, the issue is, what is he going to say in this case? And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr. Zook, now, while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department, so the defense canceled his subpoena and did not proceed with the pretrial interview. So he was not interviewed. We would respectfully ask that because of the fact that the state has not interviewed these witnesses, and particularly Mr. Winterstern was disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the motion.
The court does not. Thank you.
Thank you.
Good morning, Your Honor.
One.
So we'll start first with Christopher Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. And at any point they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so I do have an Exhibit A, which is to this motion, if I may approach, Your Honor. And what I've presented the court with is a series of emails that were exchanged between the parties. And these begin with the request that the state made for witness interviews in this case. And as the court can see, and as the state has already conceded, Mr. Zook is absent from their request. Now, the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor. And we canceled the pretrial interview that we had set for our own benefit for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. And one of the ways that we see this is that with respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory. Later, certainly there was the grand jury presentation. Now, there was really not much of anything related to Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually on the rust set. They didn't call a single one to testify. And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit, Your Honor, if I may approach. And the exhibit that I've just now handed to the court, which would be then Exhibit B to this response, is an email correspondence between, again, the state and the defense, wherein, as the court can see, and I think the court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023, the defense inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit actually is efficient, that we don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on. The state, through Ms. Morrissey, then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was. They knew that we were thinking, because of the prior conversations that we had had with Ms. Morrissey, that this was not a theory that they were going to proceed under. Additionally, Your Honor, with respect to the witnesses that they've listed in the actual case itself, and this again goes beyond just the grand jury, in the case itself, the state has not listed a single one of the producers who were on the Rust film, not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed, basically for the first time to us, their intent to proceed under this additional theory through some of the motion practice when we filed a motion related to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory. And he was not on the witness list to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern was not relevant to the defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern, and during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as a producer.
When was this pretrial interview?
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th of 2024, he was asked a number of questions about his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim. and that this is a much more appropriate witness than any of the three whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor. Thank you. Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case. Because in Gutierrez, he was listed as a witness for the state. In this case, the defense is calling him. The state has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it was in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets, what his responsibilities are. And so, as we'll argue in the 404 or the intrinsic evidence motion, this particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, in page 186 to 187 of the grand jury transcript, which was attached to the state's June 21st, 2024 response to the defendant's motion to file a supplemental brief, Ms. Morrissey goes into great detail with Mr. Carpenter, the state's expert, about Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well, and so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr. Well, first, with respect to both of them, I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Lingerstein available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for you?
We can confer with the state and work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So I'll start with these. All right, state's motion in limine to exclude evidence or separate civil suits against defendant and or Rust Productions. And you know, if you're going to do a reply, you're going to need to figure out how you're going to do that. 3 minutes for the reply.
Thank you.
Okay.
I'll be brief. This one's
And
not
I hate to tell you, I'm going to cut you off right away. Okay?
understood, Your Honor. Your Honor, in this particular case, as the court is aware, there have been multiple civil lawsuits filed against Russ Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand, has since been settled. There are 3 other states' witnesses, or 4, I believe, other states' witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit. And there's a case right on point, which I cited in the motion, which is United States versus Whitehead. It's a U.S. 10th Circuit Court of Appeals decision, 562 Federal Appendix at 701, wherein the court affirmed the district court's denial of cross-examination on a civil lawsuit that was related to the criminal case, but that had since been settled before the criminal case went forward. And that's the issue with regard to Mr. Souza. The fact that he had a civil lawsuit and settled it is irrelevant and should not be allowed. With regard to the other witnesses, Your Honor, although we understand and the state acknowledges that under State versus Santillanes, the court noted that the pendency of a civil action by prosecuting witnesses seeking damages is a proper subject of inquiry. But the court also recognized that it's proper if the civil action is for the same offense that is being tried. And that's where the state respectfully submits there is a distinction between the pending civil lawsuits that 4 of the state's witnesses have versus what the court looked at in Santillanes. My understanding is that the pending civil lawsuits that the 4 states' witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between October 6th and October 21 of 2021. So it's not specifically related to the charge that the defendant is facing. Now, if someone had a pending wrongful death lawsuit, I would concede that that is germane and is subject to cross-examination. But because there is a difference between the civil lawsuits and this pending criminal prosecution, we would respectfully request that the court deny or preclude the defense from questioning these witnesses about their pending civil lawsuits, unless the court has any questions, Your Honor. Thank you.
Your Honor, the defense has no present intention of questioning Mr. Souza about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was 0 financial motive. In this case, there is suits against Mr. Baldwin directly, an extreme financial motive. And number 3, the lawsuits are exactly on point. It almost actually looks, if you look at the lawsuits versus the state's case, like they copied and pasted it. And I know this case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them if that's the reason they're testifying in a certain way. And that's what the Confrontation Clause promises us, and that's what the Constitution demands. I have nothing further.
Any reply?
Just very briefly, Your Honor, it's a fine distinction, and it's made in State versus Santillanes. If the civil action, and I quote, was for the same offense being tried in a criminal action, absolutely agree, it would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal prosecution. So we'd ask that the court preclude any cross-examination.
All right, the court makes the following ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied. All right, next up is defendant Alec Baldwin's motion in limine to preclude improper impeachment evidence. Is that what you all have as the next one? Or was that at the end?
Is there a number?
Is it
Well,
Baldwin?
that's the problem. In the beginning, you didn't number.
That's my fault. I'll take responsibility for all faults to date.
Okay, so you want to do these at the end, and you want to start with what do you want to do?
I'm happy to do motion, what looks to me like motion eliminate 1 from,
Okay,
the-
we'll do
the
these other
defense.
ones later. All right. Defendant Alec Baldwin's motion in limine to preclude improper prosecutorial conduct and require an orderly trial.
and yes, Your Honor, I think this is a good place to start today, because this is sort of my main issue throughout the day and what I'm going to ask to address at various points, and that's why I'm going to keep my remarks so brief on all my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation, where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country. So the reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before, but it's objection, this witness doesn't know that, objection, they don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so, this is, it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor. And so eventually the court at some point stopped Ms. Morrissey from doing the coaching, speaking objections, and then Ms. Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question, and she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
Thank you, Your Honor.
Your Honor, I think we can agree on one thing. Absolutely, without a doubt, and that's beyond dispute, the state has the burden. And the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and has been allowed, and in fact, in State v. Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory. But the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, we will not, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to vouching for opinion or for witnesses, I agree it is improper to vouch for a witness's credibility. But there are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper, absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed to argue to the jury that this witness has testified truthfully based on the evidence. And finally, part of this, during closing argument, Your Honor. Yes, no, not during the trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
No, Your Honor.
All right. Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial. So...
Yeah, just a point of clarification. I don't have any intention of approaching during the trial other than the rarest of circumstances.
No. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay, I have to internalize this. I've never had a trial conducted that way, so I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask that the...
This is, a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to, the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
And may I just approach for just
Yes.
a second? So I'm glad I saved my rebuttal because I do want to address this issue, Your Honor. What I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and disrupt the defense. It is not, as I think the court will acknowledge, it is true, the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion. What happened at the prior trial, I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us at least, if after the first witness even, the court wants to revert to what they did later on in the Hannah Gutierrez retrial, but I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way, and then the court can, like this, and not hear from me further on this issue. Thank you.
I'm not going to change my mind. I can see, what I want to do is I want to start with you all getting the lay of the land. And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this, because it can happen, and it does happen. So that's what I'm going to do. If you all seem to be doing well, and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay? All right. So, I don't know what, I basically didn't really rule, except that I'm in control of the courtroom. All right, thank you. All right, next up is State's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but this case isn't about the medical issues of Ms. Hutchins, and we're going to address these issues in another bill.
What is the bottom line? You are no objection?
No objection, Your Honor.
All right. All right, no objection. Let me just write this down. All right, so the motion is granted. All right, defendant's motion limine number 2 to preclude inadmissible character and prior evidence and statements unrelated to the events of October 21, 2021.
Good morning, Your Honor. It's nice to finally see you in person. Thank you. So I'll be brief. You just heard Ms. Johnson, in response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier, or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must be excluded, Your Honor. The state cites 3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The U.S. v. Reggio case. They say Reggio was a commercial trucking driver, and the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured because he swore at someone on the 16th or threw a gun on the ground on the 16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite two other cases, the Coughlin and Lambert cases. Coughlin, they say, the court allowed the government to introduce evidence of his prior athletic activities when he had submitted a victim's compensation claim after being injured at 9/11. The state says, see, look, prior activities, case now about a fraudulent claim, 9/11. But he wasn't actually injured at 9/11 as severely as he said he was, because look at, he's running around, he's an athlete. He's clearly not injured. So it had nothing to do with propensity, it had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case. It's a bank robbery case. The defendant was talking about robbing a bank before, planning the locations, plotting it out. And then, lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence. The court says, no, you were talking about robbing a bank. You were planning the location. That is directly linked to the fact that you did, according to the state. So all of the cases they cite have a very direct link. The evidence that they're trying to admit against Mr. Baldwin, it's all propensity. Mr. Baldwin's not a murderer on the 21st because he swore on the 16th. They're going to try to show that. That's highly improper. It should be excluded. Thank you, Your Honor.
May I please the court? Your Honor, first, these other acts evidence constitute res justi. This is intrinsic evidence. And I can tell you I'm intimately familiar with the United States versus Riego case because that was my case. Mr. Riego was charged with 4 counts of involuntary manslaughter. And the court allowed the introduction of his prior medical records from about 2 years before the incident happened. So the traffic accident happened on September 7th, 2019. And Mr. Riego was driving on the interstate on a phone call with his wife. And then he unfortunately crashed into the victims and killed 4 people. The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also the court noted in allowing this as res justi or intrinsic evidence that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. And the uniform jury instruction, and it's cited in the Henley opinion, that the defendant should have known of the danger involved in his or her actions and continued to act. So intrinsic evidence is evidence that is directly connected or provides context to the jury of the charged offense, and it provides actual circumstances. So what the defense wants is for the jury to be, for the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense. So I would respectfully submit, Your Honor, that this is the state has submitted this notice on June 17th as required, putting the defense on notice that these different videos show the defense. Example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74, and 76, where his face shouldn't be. There are some videos, 7 videos that show the defendant sort of horse playing around with guns, exhibits 95, 111 to 115, and 65. Evidence of the defendant using the gun as a pointer, exhibits 91 and 58. These are inextricably intertwined with what he did on October 21st, when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger. And so that prior evidence, those other acts evidence, basically put into context what happened on October 21st and established the recklessness mens rea. In the alternative, and there's another issue, Your Honor. So the defense are going to be arguing to the jury, and we've seen the preview, that this gun was modified and that it didn't work. Again, as intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine. It had no malfunctions. Every time the defendant fired it, he pulled the trigger. There were no issues. So it is actually relevant to demonstrate that there were no issues with this gun. In the alternative, Your Honor, these other instances of the defendant's conduct are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st, when he was pointing that gun at Ms. Hutchins, that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun. And it also shows that there's no mistake. The defense is going to argue, oh, this gun just discharged on its own. I didn't do anything. This is not a mistake. Each time he had his finger on the trigger, previous occasions when he shouldn't have. And so I would respectfully submit that they are admissible as intrinsic, or in the alternative under 404B. Thank you.
Any reply?
Yes, Your Honor.
Two points, Your Honor. Number one, the state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That is not what Reggio allows, not what Coughlin allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. There was no, as I said, aha moment connecting state of mind before to state of mind on the 21st. No accident happened. Reggio, the reason state of mind was inextricably linked was because he lied about his medical condition, knowing he couldn't drive. That's the proof. That was inextricable. It was a predicate act. None of these are. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground and sort of accidentally pointing it. These issues are not what they're trying to show about the 21st. He's not shooting, showing a malfunctioning gun in most of them. They're trying to bring it all in, not to show what happened on the 21st, but to use it as reckless evidence of before and therefore after. She just told you that, Your Honor. I have nothing further.
All right, thank you. You're going to see me looking at my laptop. That's because I took notes on these matters on my laptop. All right, the court rules and reasons. Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of Rust are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. This goes to facts of consequence in this action. Applying the balancing test in which the court may exclude such relevant evidence if probative value is substantially outweighed by unfair prejudice, confusing the issues, etc. The court balancing test does not weigh in favor of defendant. However, any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendants, the gun didn't work, and they're showing that it did work because he's shooting videos that show that he's cocking the gun when he doesn't need to cock the gun, goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at any of those exhibits, and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out. Okay?
Understood. Thank you.
So denied and granted in part. All right, state's motion in limine to exclude irrelevant evidence and witnesses. Let me know if you all need a bathroom break or anything. Otherwise, we're going to noon. Now you need a bathroom break.
This is state's motion in limine 3, correct?
Yes, it is.
Okay. Your Honor, we filed this motion because we understand that the defense plans to call Robert Schilling. Mr. Schilling was a private investigator that was hired, who was hired by the prior prosecution team. When Ms. Morrissey took over the case, Ms. Morrissey terminated Mr. Schilling because he had done absolutely nothing on the case, essentially. So in response, Mr. Schilling sent an email to Ms. Morrissey and copied Mr. Bowles as well, and essentially criticized the law enforcement investigation and essentially said, I can't undo this disaster of whatever, I'm paraphrasing, of this investigation. So it was essentially a strong critique of the law enforcement investigation. I would respectfully submit that under United States versus McVeigh at 153 F. 3rd, 1166, page 1192, this type of evidence is inadmissible. Now, if there was, for example, evidence of what happened to the gun is going to be admitted. The state does not dispute that or disagree with that. But just to bring in a witness to critique and criticize the law enforcement investigation is improper. And it's the type of evidence that McVeigh, the 10th Circuit Court of Appeals in McVeigh, noted would be improper. So we would ask that the court exclude Mr. Schilling from testifying, because the entire purpose is to bring him in to talk about how disappointed and disgruntled he was in terms of the investigation, but there's a motive there. He was terminated and he did nothing in the investigation. We're also asking the court exclude Sheriff Adan Mendoza from testifying. I believe the defense in one of its responses indicated that they don't plan to call Sheriff Mendoza, but in the event that they do, we'd ask that the court exclude him as irrelevant. There is nothing that Sheriff Mendoza did with regard to this substantively with regard to this investigation. He oversaw his deputies who were conducting the investigation, but he wasn't involved. And so to bring him in again is just to sit him up there to criticize the quality of the investigation. And we'd ask that his testimony be excluded as irrelevant. And I believe all he did was do some press conferences too, so I don't know if they're planning to inject that in front of the jury, and I would argue that that's irrelevant. And even if the court believes it's somehow relevant, it should be excluded under Rule 403 as more prejudicial than probative. The probative value is nil, essentially. There is another part of our motion, Your Honor. We're asking the court to exclude any argument or mention of the state's dismissal of the prior case against Mr. Baldwin. As the court knows, relevant. Those are prosecutorial decisions that have no place before the jury. I would ask that the court exclude any argument or any presentation that the state did that. We also would ask the court to preclude the defense from making arguments that are aimed at garnering sympathy. For example, that Mr. Baldwin feels remorseful is irrelevant. It doesn't go to any issue, and it invites jury nullification. So that type of argument should be precluded. I believe they conceded on the biographical information because, as we heard during many motion hearings, that Mr. Bash was the former U.S. Attorney for the Western District of Texas. That's irrelevant. Mr. Spiro was a former Assistant DA. That's irrelevant. Just like my time as an attorney for the U.S. Department of Justice is irrelevant as well. Those should be excluded. And the last part of this motion has to do with arguing inappropriate legal standards to the jury. Again, I believe in one of the motion hearings, Mr. Bash argued that, or it was argued actually to Judge Ellington before the grand jury, that the only way that the state could prove this case is if they proved that the defendant knew that there was a live round in this firearm. That's improper argument of the law. That's not what the law is. And I guess this is an issue that the court will have to take up as we proceed during trial, but just wanted to alert the court because there's been some argument in the past that the defense is trying to rewrite the law in this case, and that's improper. Unless the court has any questions, Sharon. No. Thank you.
Your Honor, just to go through quickly each of the issues, because some of them are premature and I think we can push them off and probably won't raise issues. But to start with the testimony of Mr. Schilling, Mr. Schilling signed the probable cause affidavit in this case. He was an investigator in this case, just like Detective Hancock and the others, and there hasn't been a criminal defense case in the history of criminal defense cases where the defense lawyer didn't stand up and say the government's investigation was biased or improperly motivated or incompetent. That is Hornbook law. Why didn't you follow down this lead? Why didn't you put the gloves on? Why did you turn the lapel video off then? Why didn't you turn it on? These are all issues that are central to cross-examination in a case to challenge bias, improper motive, or incompetence. We've cited dozens of cases to you, Your Honor, cases where this wasn't admitted and it was reversible error. Schilling is part of the investigation. He's relevant to bias, motivation, and competence. He should not be excluded, number one. With respect to Sheriff Mendoza, we don't presently intend to call him. It's premature, I think, to exclude him. To the extent we want to call him, circumstances come up where it's appropriate. We'll raise that with you, Your Honor, in advance. But as of right now, we don't presently intend to, so I'd ask that you hold off on ruling because it's premature. With respect to biographical information, we don't intend to present biographical information, Your Honor. Don't think that's an issue. With respect to the evidence of what Mr. Baldwin's subjective knowledge was, we don't intend to argue that we are the givers of the law. Your Honor will, of course, instruct the jury as to what the law is. We do intend to argue that Mr. Baldwin didn't have subjective knowledge of a substantial risk to Ms. Hutchins' life because there wasn't a live bullet. In his mind, he didn't think there was a live bullet in the gun. You'll instruct the jury what they do with that, but that's certainly something we should be able to argue as to his state of mind. We won't tell the jury instructions. We won't tell them what to do. You will, of course, do that, Your Honor. And so you should deny the motion with respect to that issue. We don't intend to raise that either, Your Honor.
Thank you.
And again, if it comes up where there's a circumstance where it's appropriate, we don't foresee that at all, Your Honor, then we'll raise that with you, but we certainly don't intend to raise that.
And the garnering sympathy?
Same thing, Your Honor. We don't intend to raise those issues.
Okay, thank you.
You're welcome.
All right. The court rules and reasons as follows. The court finds that Robert Schilling's testimony regarding the Santa Fe County Sheriff's Office investigation as to what he saw and learned during the investigation is relevant. The state will present evidence of its investigation and how Mr. Baldwin came to be charged as a defendant for involuntary manslaughter. Mr. Schilling's testimony addresses that part of the state's presentation of evidence at the trial and the investigation is of consequence in determining the charges against Mr. Baldwin. The probative value of his testimony is not substantially outweighed by a danger of unfair prejudice. I will reserve on Sheriff Mendoza. Nole Prosecchi is stipulated to that it will be not introduced. The garnering sympathy is stipulated to that it will not be introduced. And I'm not going to, certainly you all can describe in opening statement what you think the facts are intended to show, and I think that you can describe what Mr. Baldwin's state of mind was without going into the elements. Okay? So it's granted and denied in part. All right, next up. This is State's motion limiting number 3. Defendant Alec Baldwin's motion in limine to preclude argument, testimony, and evidence relating to Baldwin's role as a producer.
It's the defense motion?
Yes.
Okay, sorry.
Did we? Yeah, I just did yours. Now it's theirs.
Thank you, Your Honor.
Your Honor, the state intends to introduce evidence of Mr. Baldwin's role as a producer, even though Mr. Baldwin's role as a producer happened leading up to October 21st. As I just said a few minutes ago, Ms. Johnson told you nothing that happened before October 2021 in those civil cases is at issue here. The whole of the negligence, October 6 to October 21, that's the civil cases. That's not why we're here today. But the producer evidence is everything leading up to October 2021, October 6th through the 21st. They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized. It's also far more prejudicial than it is probative because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's not a theory of liability, Your Honor. On top of that, there's no evidence at all, you won't hear any, that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. What else did you hear? The state said Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. Two issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
Your Honor, as the court is aware, relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that they're going to